right, so this is Chapter 19, Constitutional Issues and Fair Housing Laws. So let's go ahead and get started. So in terms of constitutional issues, we're going to look at eminent domain and the Fifth Amendment. So eminent domain is the authority of the government to take private property for public use, provided, of course, the owner is paid just compensation. So let me just remind you, the Fifth Amendment says, "Nor shall private property be taken for public use without just compensation." So yes, the government does have the power to take private property for public use, provided the landowner receives just compensation. The Fifth Amendment also has procedural protections, and it goes on to say, "No person shall be deprived of life, liberty, or property without due process of law." So in other words, you have the right to notice and an opportunity to be heard. Poletown case. This case is sad in many ways, but the Poletown neighborhood was a neighborhood in the city of Detroit, and it's a landmark eminent domain case in which the plaintiffs challenged whether the government's taking was legal. The basic facts are as follows. The Poletown Neighborhood Council, or the PNC, is an unincorporated association of 10 residents of Poletown. And the PNC sued the city of Detroit for an alleged unlawful exercise of its power of eminent domain. In a sad case, the city of Detroit condemned an area known as Poletown and relocated 1,362 households and acquired over 150 private businesses. And why did they do that? Well, GM wanted to build a new assembly plant. The property was acquired by the Detroit Economic Development Corporation, and they then planned to sell it to GM to build this new factory. And the issue in this case was, is this a lawful taking pursuant to the power of eminent domain? In other words, can the city condemn private property, then convey it to another private person in order to bolster the economy? And of course, now we know, after the fairly recent Kelo case, the answer to that is yes. Sadly, what I will tell you is that all these residents were relocated. A neighborhood essentially was disassembled, and the plant was never built. I invite you to look at the slides that I posted on Canvas, and you will see the YouTube video at the bottom, and it's about 2.5 minutes long, and it's narrated by someone whose family was a resident of Poletown. So I think it's worth taking 2.5 minutes to look at this one. There is a related case to the Poletown case, and it's Michael's Prescriptions. And this was a drugstore that was located in the Poletown neighborhood. And Michael's Prescriptions was located right across the street from St. Joseph Mercy Hospital, and also right next door to the Samaritan Medical Clinic. It had been in this location for 40 years, and it had a lot of traffic. It was a very small space, and it was operated by Mr. Kablak. And because of its unique location, the pharmacy was extremely successful. And Mr. Kablak had looked for a similar location or a similar traffic pattern in another part of Detroit, but was unsuccessful. And so the question for the court was, not just can they take Michael's Prescriptions, but how much is the business worth? And so how do you value a business like this? So the issue was, did the jury err or make a mistake in awarding the owner of Michael's Prescriptions $275,000 as compensation for the city's taking of the property? This figure included goodwill and its value as a going concern. And the court held that no, that would be acceptable in this case, while generally when a business is condemned pursuant to eminent domain, the business is not compensated for being an ongoing concern. This was such a unique situation that Mr. Kablak did receive compensation for being an ongoing concern. All right, so the next case is probably the most unpopular Supreme Court case, at least in modern memory, within our memory. Of course, Plessy versus Ferguson is probably the least popular, but after Poletown, the Kelo case was heard. In Kelo versus City of New London, the United States Supreme Court weighed in. This too, I invite you to look at this very short YouTube video. It's about 2.5 minutes long, explaining a little bit about the Kelo case. So, basic facts in this case: the City of New London used a state law to condemn non-blighted land. They were going to build sell this land to other businesses, and essentially they wanted to support the revitalization of the city's downtown. So there was a proposed pharmaceutical factory to be put in that spot. Condominiums, other businesses were to be located there too. 7 plaintiffs challenged this taking. This too, the Fort Trumbull neighborhood, was a vibrant neighborhood, and this house is Suzette Kelo's house. And so Suzette Kelo objected to having her house taken by eminent domain. She'd worked very hard for this house, and she loved this house. And she said, "You cannot take my private property and convey it to another private entity." And so the case went up to the United States Supreme Court, and was this a valid taking? Well, the answer the Supreme Court came back with was yes, it was a valid taking. Very unpopular case, and I suggest that you take a look at this case and decide for yourself. But what I will tell you is that after the Kelo case came out, the United States Supreme Court had given states permission to change their state constitution, to make the state constitution say that in order for property to be taken by eminent domain, it must not just be for it must be for not only a public purpose, but for a public use. So for instance, a public use would be as a school or as a hospital or for a road. So over half of the constitutions in the United States, state constitutions, have been changed so that today in Virginia, for instance, we would not have the Suzette Kelo's result unless the property was being taken for a public use, not just a public purpose, but a public use. All right, so moving right along, here's another case for you to consider: Loretto versus Teleprompter of Manhattan. So the question in this case was, is the permanent installation of cable TV equipment on a roof a taking, and thus compensable? So here there's a New York statute that required landlords to permit cable TV companies to install equipment on their property so the tenants could have access to cable TV. You know, property in New York is very valuable. Every square inch is valuable, including rooftop property. So in this case, the cable TV equipment was installed permanently on Loretto's roof. So is this a taking? And the court held that yes, a permanent physical occupation constitutes a taking, and the amount of compensation would be up to the state court. All right, so on to some fair housing laws. So there are both federal and state fair housing laws, and there's a very practical reason for you to be aware of federal and state housing laws, because failure to follow these laws could result in suspension of your license or even loss of your license, not to mention embarrassment and significant monetary fines. On the positive side, following fair housing laws makes for a diverse real estate practice, and in the real estate business, it's good business. And in fact, in every business, it's good business to treat people fairly. So, in practice, licensee should have a working knowledge of federal, state, and local fair housing laws. And the good news is this: Virginia's fair housing laws are virtually identical to federal fair housing laws. There are certain protected classes. So protected classes include: you may not discriminate on the basis of race, color, religion, national origin, sex, elderliness, in Virginia that is age 55 and up, familial status, and you may not discriminate on the basis of handicap. All right, equal opportunity in housing. So the effort to guarantee equal housing opportunities began with the passage of the Civil Rights Act of 1866. This law specifically prohibited any type of discrimination based on race. Unfortunately, that unpopular Supreme Court case I mentioned earlier, Plessy versus Ferguson, came down in 1896. And this is the case where the United States Supreme Court established the doctrine of separate but equal, essentially legalizing segregation. What I will tell you is that between 1948 and 1968, there were several Supreme Court cases that addressed the inequalities in housing. However, these cases were limited in scope and really didn't do the job. So it wasn't until the Civil Rights Act of 1968, specifically Title VIII, also known as the Federal Fair Housing Act, that we had a law that specifically prohibited discrimination on the basis of race, color, religion, sex, handicap, familial status, or national origin. This law also prohibits discrimination against individuals because of their association with a person in the protected class. The law is administered by HUD, and on the HUD website, there is an online and a printable complaint form for people who have been discriminated against. All right, so very briefly, family status. Fair housing laws protect individuals under the age of 18 who live with a parent or legal custodian. The family status rules also apply to pregnant women. So, in effect, the Fair Housing Act's protection extends to families with children unless a property qualifies as housing for older persons. In other words, all properties must be made available to families with children under the same terms and conditions as to anyone else. All right, so it would be illegal to advertise that a property is for adults only or to indicate a preference for the number of children. The occupancy standards must also be reasonable. So there are objective factors such as sanitation or safety that you could use to determine occupancy. So the exception is property for older people, that is 55 and up. And so in Virginia, the Virginia Fair Housing Law says that elderly is a person who has reached their 55th birthday. And while the Fair Housing Act protects families with children, it is legal for housing, to create housing intended for people who are older. There are certain restrictions, and I'm not going to require that you memorize those restrictions, but it would be legal. All right, so what about disabilities? So a condition is considered to be a disability if there's a physical or mental impairment that limits one or more life activities. I will tell you that people with AIDS are protected by the Fair Housing Act. It's considered to be a disability. But my note to you is this: a person who is currently using or abusing illegal drugs or controlled substances is not protected under the Fair Housing Act. In addition, people who have been convicted of manufacturing or distributing illegal drugs are not protected. But the Fair Housing Act does prohibit discrimination against people in addiction recovery programs. So, bottom line is this: it is unlawful for landlords to discriminate against buyers or tenants on the basis of a disability. Landlords must make reasonable accommodations to existing policies or practices to permit people with disabilities to have equal access to the premises. People with disabilities must be permitted to make reasonable modifications to the premises at their expense. And if these modifications make a rental property undesirable to the general public, the landlord is allowed to require that the premises be restored to its previous condition at the tenant's expense. My note to you is this: it is permissible to restrict occupancy to persons with handicaps. New multifamily dwellings. that is if you have 4 or more units, must be designed and constructed in a way that the common areas are readily accessible to handicapped persons. All ground floor units must allow passage by persons in wheelchairs, and kitchens and bathrooms must be designed for full maneuverability. Racial discrimination is absolutely not allowed. In Jones versus Mayer in 1968, the United States Supreme Court held that where race is involved, there are no exceptions to the fair housing law. And this is an important case because the court also expanded the definition of race to include ancestral and ethnic characteristics that are shared by a group with a common national origin. Again, Jones versus Mayer is important because Fair Housing Act does have certain exemptions, and we'll look at what those exemptions are on the next slide. However, there is never an exemption where race is involved. So here are the exemptions to the law. In other words, you don't have to comply with the Fair Housing Act if you fall under one of these exemptions. So if you have an owner-occupied dwelling with no more than 4 units, in addition, a single-family housing that is sold or rented without a broker could be exempt. Housing that is owned by a club, so a social club, if a social club owns housing, it could be exempt. However, remember again, you may not discriminate on the basis of race, even if you fall under one of these exemptions, and that's what the Jones versus Mayer case stands for. Religious organizations, so housing owned by religious organizations. Religious organizations may limit the sale or rental to members, provided that membership is not restricted on the basis of race, color, religion, national origin, sex, elderliness, family status, or handicap. And also, private or state-owned educational institutions, hospitals, nursing homes may require single-sex occupancy. So that's another exemption to the law. Single-family occupancy. So group homes are considered to be single-family if there are no more than 8 residents. So you may not exclude a group home from a neighborhood that is zoned for single-family residence, so long as there are no more than 8 residents in that house. Sometimes there are restrictions that are established by condominium associations, and the number of occupants in a condominium may be restricted, but that restriction may not be more stringent than the local zoning ordinance. Criminal background. As I said before, it is legitimate, it is acceptable to do a background check on prospective tenants. And people convicted of drug trafficking are not protected under fair housing laws. You may not discriminate against someone who is in an addiction recovery program, but if that person has ever been convicted of drug trafficking, manufacturing, or distributing, then they are not protected and you may exclude them from your housing. So, it is illegal for a real estate licensee to be involved in discriminatory practices. And this you may not have considered to be discriminatory, but what I need to tell you is this, that you may not use words or symbols associated with a particular religion, national origin, sex, or race on your business cards. So a real estate licensee would be prohibited from putting a cross, for instance, or a Star of David on a business card. So what are some of the penalties for violating fair housing laws? They can be stiff. So the Attorney General can issue an injunction or an order to stop you from doing a certain practice. There may be civil penalties, including compensatory and punitive damages, attorney's fees, and costs. If a real estate licensee is found guilty of violating fair housing laws, the real estate board has the power to suspend or to revoke your license. All right, so what do you think of this? Would this be all right for an ad to say, females only need to apply? In general, no, unless you are a female and you are looking for a roommate. Then you could have that ad. So let's look at some real questions. Let's apply the law. So Claire owned an apartment building, and one of her elderly tenants, Mabel, was terminally ill and requested that no children be allowed in the vacant apartment next to hers. The noise would be difficult for her to tolerate. So Claire agreed and refused to rent to families with children. When sued for violating the Fair Housing Act, your answer here is B. Claire is in clear violation of the Fair Housing Act and may face penalties and sanctions. All right, so next case, is this ad legal? Sally is looking for a roommate to share her apartment at Sunchase. She takes out an ad in the Farmville Herald that says, roommate needed to share apartment, Christian females only need apply. This ad, your answer is B. This ad is in violation of the Fair Housing Act. She wouldn't be allowed. This ad is clearly illegal. Eminent domain. Which of the following does not constitute eminent domain? Your choices are a county taking a farmer's cropland for a highway. Is that eminent domain? Yes. B, the state taking a private woodland for the construction of a roadside visitor center. Is that eminent domain? Yes. C, a county zoning ordinance change. No. Or D, Longwood University condemning a house on High Street for an alumni center. Yes, that would be eminent domain. So your answer here is C, that is not eminent domain. So what is just compensation? For condemnation purposes, pursuant to an eminent domain cause of action, just compensation means, it means A, fair market value at the time of the taking. By the way, that question is on the test. A condemnation suit, if there's an eminent domain cause of action, what must happen before a condemnation suit is actually initiated? And the answer is this: there must be a genuine but ineffective effort to purchase the property. That has to happen first before a condemnation suit is initiated. All right, so that's it for constitutional law and fair housing. Thank you.